بسم الله الرحمن الرحيم الحمد لله والصلاة والسلام على سيدنا رسول الله وعلى آله وصحبه ومن والاه. Welcome back, first of all. Inshallah, in today's class, we are going to talk further about this larger topic of the etiquette of the judge, and we're going to talk about how or who begins the discourse when there is a plaintiff and a defendant, and the judge is supposed to hear from the plaintiff first, and then the defendant. And we will also learn that the plaintiff will have the opportunity, as I said, to begin, but to give all of the evidence, and then the defendant can respond, either affirming part of what was said, the claims against him, or to defend himself or herself. And the defendant does not swear an oath against those claims unless the plaintiff asks for it. So here we're going to kind of get into a little bit of a different style of a court procedure than we might normally be thinking of if we're thinking of sort of like the Western court system. There's a little bit of a difference, remember, because there's no lawyers involved. And then we learned that the judge is not meant to badger the witness, nor to accept testimony except from a witness whose uprightness has been established. And in this, we will have an echo from the books of the hadith nomenclature, mustalah al-hadith, which we talked about ilm al-rijal, we talked about al-jarh and al-ta'dil, those type of issues. This is basically the same thing. So this is another point, as I try to make reference throughout the course and throughout the classes for you. This is a point where we have a convergence of the different subjects. So we're going to talk about that a little bit. And then the last thing is who we do not take testimony from. So we don't take testimony of an enemy against an enemy, or a son testifying for his father, or a father testifying for his son. Obviously, for obvious reasons, there's major conflicts of interest when it comes to those things. So this is a normal kind of discussion, nothing too abstract and strange. Only to mention, as I just said a little while ago, that there is a little bit of a difference of how the procedure goes. So just keep that in mind so that you're not biased with what you might think is a kind of a romantic view of a court scene. Anyway, those are the main topics for today's lecture. We'll jump right in the next clip, inshallah. So we begin the way we always begin, which is to turn directly to the text of Abi Shuja' radiallahu anhu in the original Arabic. بسم الله الرحمن الرحيم قال المصنف رحمه الله ونفعنا بعلومه في الدارين آمين ولا يسأل المدعى عليه إلا بعد كمال الدعوة ولا يحلفه إلا بعد سؤال المدعي ولا يلقن خصما حجة ولا يفهمه كلاما ولا يتعنت بالشهداء ولا يقبل الشهادة إلا ممن ثبتت عدالته ولا يقبل شهادة عدو على عدوه ولا شهادة والد لولده ولا ولد لوالده. So, our beloved Qadi Abu Shuja' radiallahu anhu, he says, may Allah Ta'ala have mercy on him and may we benefit from his knowledge in this world and in the next. The judge does not question the defendant until the claim is complete, yani the claim against him is complete, and he does not have the defendant swear an oath until the plaintiff asks, because you just take what the defendant says at face value. He does not help either party, meaning the judge. The judge does not help either party formulate their proof against their opponent, nor does he explain how to make an allegation. So there's kind of no coaching involved, except to ask kind of explanatory questions, which we'll get into. The judge does not badger the witness, nor accept testimony except from a witness whose uprightness has been established. A judge does not accept an enemy testifying against an enemy, a son testifying for his father, or a father for his son. Okay, let us look at the Adillah book really quickly to see if there's some stuff to bring out for all of us. As far as the badgering is, part, that comes part of it from Al-Baqarah, verse 282, which is Ayatul Dain as it's referred. وَلَا يُضَارَ كَاتِبٌ وَلَا شَهِيدٌ وَإِن تَفْعَلُوا فَإِنَّهُ فُسُوقٌ بِكُمْ. So do not harm or badger, I guess would be the word to be consistent, those that are coming before the court with those type of testimonies, etc. As far as the not accepting the testimony of people that are not upright, we have the hadith in the Tirmidhi. The hadith of Abu Dawood narrated on the authority of Abdullah ibn Amr ibn al-As radiallahu anhuma, that the Prophet ﷺ said, لا تجوز شهادة خائن ولا خائنة ولا زان ولا زانية ولا ذي غمر على أخيه. So the testimony of, a not upright, a kha'in is somebody who's basically a deceiver, or a liar, is not accepted, nor of a person who commits zina, man or woman, etc. Okay, well, that's it for the Adillah book. Now, the Adillah book, I should mention, sometimes it's like today, it's very thin. That doesn't mean that there's not Adillah. This is just one book that I frequently use because it's the Adillah directly on the matn of Abi Shuja'. But when we do the book of Shaykh al-Islam Zakaria al-Ansari, and we talk about the Adillah, we'll find much more there, and also Bulugh al-Maram of Ibn Hajar al-Asqalani radiallahu anhu, which is probably one of the main books of Adillah. I think Ibn Daqiq al-Eid radiallahu anhu, I think it's Umdat al-Ahkam, he has another book. So there are famous ones. So I'm not relying on them because that's not the focus here. The focus is just trying to give you like a little snippets here and there. Okay, anyway, let's come back to the text and make our way through the commentary. So the first thing we read is that the judge does not question the defendant until the claim is complete, and he does not have the defendant swear an oath until the plaintiff asks. So when two people come before the judge, the first thing the judge needs to do is he needs to hear the claim, which is from the plaintiff's side. So let's say person A is the plaintiff and person B is the defendant. Person A is making a claim against person B. That's the basic kind of idea. And the person B is there to defend themselves. So because the person B in my example is there to defend themselves, they have to hear the claim first, so from which and to which they respond and defend themselves. So the first thing is the judge has to hear those type of claims. Now, and then the judge gives the plaintiff the opportunity to exhaust, what they need to exhaust in making their claim. That's their right. Then the judge turns to the defendant and asks him to respond. If the defendant confirms what the plaintiff said, then there is no ruling of the judge, because the confirmation of the defendant is a proof in and of itself. There was a claim against somebody and then they confirmed it, then khalas, it's done. It's what needs to happen, and what needs to be done, needs to be done. There's no court ruling in that case because there's no disagreement. If the defendant acknowledges all, some, or part of what the plaintiff said, there can be no going back on that confirmation. So if, let's say, somebody is saying that I stole this book, and part of the narrative is that I'm going to say, I guess in that case I'm the defendant. So somebody, this book was stolen from me, and I'm going to go and make a claim against person B and say, this is like the evidence. This book, which is mine, was stolen. So the other person can say, yes, I confirm that that's Tariq's book. but it didn't, it didn't sell it. So that part, that's the little overlap in which there's a claim that's made, and then the defendant confirms that claim, then that becomes an established fact, and then in that case, the defendant cannot go back against it. Now, obviously, usually what's going to happen is the defendant is going to argue and respond and say no, in which case the judge will then give them the opportunity to bring evidence or to bring somebody to testify to their response to that claim. If I'm not mistaken, the testimony will come later, which we will get into this unit. That's the last. So we'll just keep a mental note that we're going to come back to talk about the testimony. Okay, so the order is that the judge has two people before them, the plaintiff A, the defendant B. The judge has to hear from plaintiff A first. They've exhausted everything, then gives B, the defendant, an opportunity to respond to the claims against them. If any part of the claim of A or all of it is confirmed by the defendant for whatever reason, then that becomes locked in as fact, and then the defendant cannot go back against it. If, which is probably usually the case, the defendant is going to defend and rebut that, then the judge gives them an opportunity to bring forth their evidence, the burhan, the bayina, or to have a witness that comes and testifies and is sworn in, their testimony is sworn into the court. Okay, I think that's pretty straightforward. I think we kind of understand that. So let me just read that sentence before we move on. The judge does not question the defendant until the claim is complete, meaning the claim against the plaintiff is complete, and he does not have the defendant swear an oath until the plaintiff asks. So there's the testimony of the defendant, but then if the plaintiff asks the judge, this cannot come from the judge, if the plaintiff asks, I want that testimony to be sworn, and it's like a sworn statement or a sworn affidavit, then the judge has to comply and have the defendant swear that. If the defendant swears before the plaintiff asks for it, that does not count. It has to happen after the plaintiff asks for the testimony or the claim of the defendant to be sworn. Okay, let me pick up the discussion in the next clip, inshallah. Okay, so now let's get to the next section. The judge does not help either party formulate their proof against their opponent, nor does he explain how to make an allegation. So this is kind of like what we took in the last lecture about the judge having to be equitable. The judge is not there to coach them or to tell them how to do it. The judge has to hear from them unencumbered. The judge can ask clarification questions. The judge can ask for things to be clarified in the testimony, because sometimes people are sloppy when they speak, or they are too general, or they're not specific enough. Well, I guess that's the same thing. Or they are using the wrong words or misusing words. That happens a lot. I mean, especially in my experience, when people come and ask questions, a lot of times they kind of have an inkling of what they're trying to ask when it comes to Islamic related stuff, but they don't have the literacy to ask the right questions. So sometimes you'll be like, oh, do you mean 1, 2, 3? Because what you just said really means something else. That's different. But the judge can't say to the plaintiff, no, what you need to do is say such and such, and that's not for the judge to do. Probably this is maybe where kind of the idea of a lawyer emerged, I think, in the Western case, in the Western legal example, because most people are unable to do that. I mean, at least in the modern world, I have found most people are unable to do that effectively. I don't think there's any opposition necessarily to lawyers in this case, because the lawyer would kind of be like a wakil, would be a deputy or somebody that you've authorized. So one could, imagine if an elderly woman or a child, they have to be represented by somebody. So I don't think there's anything against that necessarily in the Sharia. But let's just take it as a simple understanding that there's no coaching back and forth. He says, أما استفسار الخصم فجائز. As for asking clarification questions, that's permissible. Because it doesn't injure or bias against the other side. If I told the plaintiff, if the plaintiff started speaking and I'm like, oh my God, this guy's a disaster. No, and I cut him off and I'm like, what I need you to do is say 1, 2, 3. Then it's not fair against the defendant because I've kind of aided the plaintiff's claims against the defendant because now I've helped it become more articulate. That's what we can't do. But if he says something and it's sloppy and I ask for clarification, that's different because I haven't hurt any claim. He's already made the claim. I'm just trying to understand exactly what he says. Like the example that Ibn Qasim gives and then Al-Bajuri comments on is like example if a person makes a claim of murder. So Al-Bajuri says فَهَذِهِ دَعْوَى غَيْرَ مُفَصَّلَةٍ. But this is a claim that's not very exact or precise. فيسن للقاضي استفصاله عنها ولذلك قال الشارع فيقول القاضي للمدعي قتله عمدا أو خطأ. He said, so it's a sunnah, it's a good thing for the judge to ask for a differentiation or a clarification. So therefore, as Ibn Qasim, the commentator on the Matn of Abi Shuja says, so the Qadi will ask, did he kill him amdan? Was it voluntary or khata'an or was it involuntary? What is your claim? And then he says, nor does he explain how to make an allegation. Okay, so neither are we going to formulate the proof. The judge is neither going to help formulate the proof, or I'm going to tell you, if I'm the judge, how to make the allegation. I think that's pretty clear. I think we can go on from that. And then he says, judge is not to badger the witness. So you have to have rahmah. Oftentimes, a plaintiff or a defendant can be rude, can try to play games and tricks on the court. That happens. The judge has to maintain order. There's no doubt about that. There are rules and etiquettes and procedures in the courtroom. There's no doubt about that. But it's not for the judge to bully or badger the witness, because then that will also make bias a part of the proceedings, and then it will call the whole judgment into question. Okay. Now, what does the judge not accept? Nor accept testimony. The judge does not accept testimony except from a witness whose uprightness has been established. Okay, so this is going to take us some time. Whose uprightness has been established. So, these are the credentials of the witness. If the defendant is going to bring witnesses, or if the plaintiff brings witnesses, those witnesses themselves have to be verified. So obviously, the plaintiff and or the defendant can't bear witness because to their uprightness, because that's a conflict of interest. And usually, when we talked about the etiquette of the qadi, let me try to go back to that for a second, if I can find it quickly. We said that the judge has the right to take certain expertise in the court, like a translator or a scribe, etc. And this is one of them, is the verifier of the uprightness of people. Every time I want to show you guys something, I can never find it right away. I apologize. Well, inshallah it will come. So it's like a job. Its job is to verify the people's uprightness. Now, if the person, well, let me just see if there's anything else in the text before I put the book away. Yeah, okay, uprightness. If the person's uprightness is called into question, either by the judge, because the judge knows that person, or they have not been verified, or they have been known to do something that is contrary to uprightness, obviously their testimony is not going to be accepted. And here we are talking about outward uprightness, not inward uprightness. Only Allah subhanahu wa ta'ala knows that, so we're just judging on what we see. Now, the witnesses and the testimonies to the witnesses' uprightness are of two kinds. There are close friends, or let's say people of the community. So let's say we're in a small town and a clerk at a store is being brought in as a witness, and we're going to have somebody verify this witness uprightness, but everyone knows that this is like little Abdullah that grew up around the corner. We all knew him. In that case, if there's a breach of, in this case, that young man's uprightness, that breach has to be made public. So the verifying agent would say, in this case, Abdullah is not upright because you have to stay. I saw him steal. I saw him fornicate. Those are the examples that he gives. On the issue of fornication, which is an interesting, because this is one of the furuq, this is one of the differences in Islamic law. Of course, if the crime of fornication and adultery requires 4 eyewitnesses of the act of penetration, which is almost impossible. And if there's less than 4, or one of the 4, or more of the 4 renege, all of the witnesses are punished. We took that in the book in a previous module. However, in this case, this is different because this is a type of shahad, it's a type of fard kifaya or fard ayn, an individual communal obligation to verify the uprightness of a witness. So therefore, you are not making a claim against the person that they should be punished for this crime. You are just saying there's a breach in their uprightness, there's a jarh, there's a breach in their uprightness because of such and such, and in that case that would be enough to call that witness into question. So if it is a close person of the community whose uprightness is being verified, the default is that people are upright. That is the default, that they're adil, that they're upright, except and unless and until evidence is brought to the contrary. So if it's somebody who's an intimate member of the community and people know, then unfortunately that breach of the uprightness must be publicly stated. Let me just get my place in the text before I move on. Okay, well I see that I'm running out of time. Let me pick this up in the next clip, inshallah. All right, continuing with this issue of the uprightness of the witnesses. Oftentimes, in the example that I was giving of like the store clerk, or everyone knows this young man that grew up, in the case in which the witness that is brought is a member of the community, and if it's a small community, the chances are very high that the judge knows this person. So if the judge knows that the person is upright, then he can accept the testimony. If the judge knows that the person is not upright, he's not allowed to accept the testimony. But if the person is not known, or their uprightness is not known, that's when you need somebody to verify, and he is needed what they call a tazkiyah, which is the word that we use for tasawwuf, tazkiyah, purification. But you need a muzakki, you need somebody who is going to verify that person's uprightness. And if the person is an intimate member of the community, or a known member of the community, I should say, then the muzakki, the one that's going to verify that uprightness, has to be honest if there is something that breaches that uprightness. As I said, they would have to say he is not upright, or she is not upright because, and then name the thing, and in which case their testimony would not be accepted. Now, to avoid the situation in which the muzakki is lying about the witness because the muzakki is in collusion with the plaintiff or the defendant, it could be a never-ending process. This is supposed to take place within the court system. So the court is supposed to have its own apparatus that verifies the veracity of the witness. In like the Western or in the American legal system, it's basically, do you swear to tell the whole truth and nothing but the truth will help you God? I do. So therefore you've been established to be upright, we'll accept your testimony, and if you're found to lie, then you've perjured yourself, or you've committed perjury, which is a major crime, which is for us meaning you have breached your muru'ah, you have breached your uprightness, your adala, and therefore your testimony will not be taken and you could be punished. So I'm using these examples to show you that there's a great deal of overlap. Now, if the person is not from the close members of the community, oh, this is the section I found it. Then, and they're like an expert witness, it is enough to establish their uprightness that the muzakki says, no, they're good to go, they're upright, or they simply say, no, they're not a reliable witness without having to state the reason. So there's a little bit difference. And this is all based on the verse in Surah At-Talaq, وَأَشْهِدُوا ذَوَيْ عَدْلٍ مِّنْكُمْ, and let the witnesses amongst you be upright. So this is a massive thing and a massive part of Islamic law, a massive part of how the Quran and the Sunnah have been narrated to us through عادل ضابط, those that are upright and accurate to those who are equally upright and accurate, etc. And also in the court cases. So we need people that are upright to bear witness, or else we're not going to be able to proceed and deal equitably and in a just fashion. And as I said, the court is meant to have an apparatus with them, experts that verify the uprightness of the witnesses. So everything that we talked about in Jarh and Ta'dil, when we did the Bayquniyya poem in the Hadith class, all of that stuff is the same stuff. Anything that would make a narrator of Hadith to be considered not upright, then it would also make their witnessing not upright. Because there is a difference between shahada and riwayah. There is a difference between bearing witness in court and riwayah, which is to narrate the conditions. And that's, if I'm not mistaken, that's the first farq, the first difference that Imam al-Qarafi has in his multi-voluminous al-Furuq. The differences in Islamic law, that things that you might think are the same, but they're different, which is a very important subfield in usul al-fiqh, which is very, very fascinating. But there's a difference between riwayah and shahada. Because shahada here, you're kind of bearing witness against other people. But the conditions for uprightness are pretty much the same. Unless we're dealing with a case, if it's like a medical case, then the person has to have knowledge of the medicine or the medical case. If the person's like a forensic accountant, I don't even know what the forensic accountants do. I know generally, but I don't know specifically, so I couldn't be a witness in something like that, so on and so forth. Other than those specifics, the same set of standards that we have for being upright and accurate, the jarh and the ta'dil are going to happen. And just like in the hadith, the jarh muqaddamun an al-ta'dil. So to look at the character of a narrator, al-jarh, and find any defects in that character is going to be put forward above the establishing the uprightness of the person. And the same thing with the witnesses. Okay, I think we kind of exhausted that, so we can move on to the next bit while we have time left. Or let me just read that last sentence so you have a full thought. He does not badger the witness. The judge does not badger the witness, nor accept testimony, except from a witness whose uprightness has been established. Okay, we got that. Now, the last part for today. The judge does not accept an enemy testifying against an enemy, a son testifying against his father, or a father against his son. Enemy against an enemy, that makes sense, because obviously they hate each other. Right? He says, but this is in the zahir, not in the batin. And Allahumma salli ala Sayyidina Muhammad. He has a beautiful hadith that I wanted to share with you, just to show you sometimes the benefits of the longer books. Yeah, I can't, again, I cannot find it here, but it will probably pop up. Here we're talking about a type of animosity that is public and that is known, not something that is hidden. because we are not tasked with something that is hidden. So, oh, sorry, there is one more thing I wanted to say about the upright witnesses. In the upright witnesses, before we get to the enemy and the enemy, part of being upright or not part of being upright if there are differences of religion or differences of madhahib. So people are able to testify against each other, and that's not necessarily considered. No, sorry, this is a subset of what I'm talking about. Animosity, sorry, enemy. Part of the enemies does not include people that are of different religions. So different people of different faiths can testify on behalf or against one another, and that's not considered a difference, an enemy. The enemy here is somebody that you don't like, that you dislike, that you have ill will towards that person publicly. That's what I was fishing for. And then the father to the son, or like grandfather for the grandchild, all the way up, and then in reverse order, in ala wa in safil, up and down the line of the lineage. But not other relatives. So brothers can against one another, so on and so forth, but not the father and the son and the father, because you cannot be the cause of your father's downfall or vice versa. See if there's anything else. There was one more line, I think, I didn't read. A judge is written, I didn't read this in the Arabic, but let me read it here and we can touch up on it if we don't do it justice in the next clip. A judge's written ruling that is sent to another judge is not accepted until two witnesses testify concerning its content, because simply the letter could have been tampered with, and that needs to be verified that it comes from the judge. So the letter in and of itself is not authoritative. What's authoritative is the pronouncement or the judgment of the other judge. So even though there are secure communications, it needs to be witnessed, and that's where the kind of the object of, or the concept of the notary comes in. The rest of the commentary, which I'll get into tomorrow about this specific point of law, he talks about those type of things, and that's also important. So there are ways, you don't have to send a letter with two witnesses, but there are ways to create an environment in which that letter is verified, but that's something that's very important to state. So it's not the letter alone, because it can be forged. There has to be witnesses to that truth. And that's very much the same way that the Quran was accepted. The verses were accepted in the final compilation of Sayyidina Abu Bakr radiallahu anhu, because there were two witnesses for each verse, same kind of concept. Anyway, we'll put a pin in it here, and I'll pick up on this tomorrow, inshallah. والله تعالى أعلى وأعلم وصلى اللهم على سيدنا ومولانا محمد وعلى آله وصحبه وسلم. Alhamdulillah, we've almost finished this current section that we're doing about the etiquette of the judge. There's a little bit left for tomorrow's class, inshallah. But the main topics that we talked about today were the order in which the judge hears the case. So he hears from the plaintiff first, and then from the defendant. The judge does not ask the defendant to swear an oath or to swear their testimony into the record unless the plaintiff asks that to take place. Then we also learned that the judge is not to help any party formulate their proof against one another, nor to explain how they are to make an allegation, because that would be an act of impropriety and would cause us to call into question the whole legal proceeding, because it would be biased. The judge can ask clarifying questions and must in order to gain clarity. The judge does not badger the witness, we talked about that, nor accepts testimony except from a witness whose uprightness has been established. We spent the bulk talking about that, and those are concepts and a discussion that we simply borrow from the discussion of hadith, of mustalah al-hadith and jarh and ta'dil, all of those things that we took when we discussed the Bayquniyah together. So we learned about what being an upright person is and how to verify the uprightness of a witness, that there is an apparatus or experts in the court under the judge's orders and direction to be able to verify the different witnesses, whether the witnesses be of the immediate community or whether they be expert witnesses that are brought from outside the community. And then in the last bit we talked about we cannot accept testimony of an enemy against an enemy not being opposites like different religions or different madhabs, but having ill will towards one another, nor a son against the father or a father for the son, or however up or lower you go in the nasab. And then lastly, I just kind of brought in this line about a judge not accepting the written ruling of another judge unless it's accompanied by two witnesses, because it needs to be verified, and the letter alone could be forged. And that's the point that we will pick up in tomorrow, because there's a lot more discussion about the details of the verifying of that letter or the written format, which is important because our religion is based on verification, on the tawfiq. Those are the major topics that we talked about. Walhamdulillahi Rabbil Alameen. Wa sallallahu ala Sayyidina wa Mawlana Muhammad wa ala alihi wa sahbihi wa sallam.